Hello. Eric the Fatid made a comment on my video suggesting that Terry v. Ohio is not about searches and seizures. All it's about is pat downs. Pat downs. It's the pat down case. That's all it's about. And that's funny because when I was going to law school, which admittedly was a long time ago, they taught Terry v. Ohio in the context of searches and seizures. See, the defense was trying to suppress the firearms that were found as evidence. And they tried to suppress it using two different tactics. Tactic number one was that the seizure of Terry was in violation of his Fourth Amendment rights. And the court said, well, yes, it was a seizure, but it was reasonable. And the Fourth Amendment only protects you from unreasonable searches and seizures. Investigatory detentions are seizures. So Terry v. Ohio deals with seizures. And that's why we talk about Terry v. Ohio when we talk about detentions. And the second part that the defense tried to use to suppress the firearms was that the search was a violation of Terry's Fourth Amendment right. There was no probable cause. There was no warrant. And the court said, yeah, but the search was reasonable. Officer McFadden reasonably suspected that Terry was dangerous, either to Officer McFadden or to the surrounding citizens. There was a danger to Officer McFadden or others. And so Officer McFadden was reasonable in doing his pat down. It wasn't too terribly invasive, but it was reasonable. And again, the Fourth Amendment only protects you from unreasonable searches and seizures. So Terry v. Ohio deals with searches and seizures. Now that second part, that the search part might give you pause. If Officer McFadden, if it was reasonable for Officer McFadden to search Terry for a firearm or other weapon, because Officer McFadden thought that Terry might be a danger to Officer McFadden or others, what do you think the court was thinking that Officer McFadden was going to do with said firearm when he found it? Well, they already knew what he would do when he found it, because he found it and he seized it. And it's not an issue. It's not a problem. You know why it's not a problem? Because it's reasonable. It's goddamn reasonable. Now, Terry v. Ohio didn't address that issue. They just assumed that Officer McFadden could do it. It's not a problem. It's not a problem because Terry's dangerous. He's an armed robber who's armed with a firearm. Or he's going to be an armed robber. So there you go. There's a problem. Now, relating back to the CCW's video, did the officer have reasonable suspicion for the detention? Yes, absolutely he did. He had reasonable suspicion for the detention because he was responding to a call about someone making criminal threats. Now, if it was a call about suspicious activity, then not reasonable. But it was a call about somebody making criminal threats. And if somebody's making criminal threats, officers are going to take that seriously. That is their reasonable, articulable suspicion. I had a call of someone complaining about a felony, somebody making criminal threats. I was responding to a felony. And you could also add on the extra stuff when you get there. The CCW is acting aggressive and hyper and just not normal. And the officer can tag all those things together. And then the officer sees a weapon on him. It's a small pocket knife, 2.5 inches, but they killed people with smaller blades in prison. I mean, they kill people with like razor blades and sharpened toothbrushes. So a 2.5 inch blade would be a luxury for them to kill with. You can kill someone with a 2.5 inch blade. That's what I'm saying. So the officer can put all these little factors together and think it's fucking reasonable to to detain the CCW. And when he's detained, again, he's being detained for a crime of threats to commit bodily harm or murder. That's reasonable suspicion that he's a danger to the officer or to the others. Therefore, he gets to disarm you. And even if there wasn't, when you're being detained, the officers might not be able to pat you down, but if they see a weapon on you, they can take the weapon just for officer safety. And your recourse is basically nothing. If you tried to sue them over it, you were deprived a weapon while you were in police custody. You weren't under... the police are there to protect you guys. So you're not under any danger. You weren't supposed to use it while you're in police custody anyway. Or not custody, but while you're detained anyway. I mean, you're not going to get a recovery civilly, and they haven't violated any criminal laws, so you have no real recourse. Anyway, so there was reasonable suspicion for the detention of the CCW, and disarming him was reasonable, especially considering the circumstances. I'm going to go out on a limb on that. Now, I'm not saying that the CCW made a threat. I didn't see a threat. I listened to the video. I listened to it at 2 times speed. I may have missed something, but I didn't hear him make a threat. Now, 2 things. People think that the ride wasn't justified. The detention was, but the arrest wasn't. Number one, we don't know what happened before his camera started rolling. When I watched it, it started off, he was already out of the car. He was at the corner. He was already yelling when the video I saw started. So again, in media res, we don't know what happened before it. If the alleged threat was made before his camera started rolling, I don't know. You don't know. He says he has dash cam. I don't know if his dash cam would have caught the period of time from after he got out of his vehicle till he started his other camera rolling. I don't know. So I didn't see any criminal threats, but the officers, they have a witness saying there was a criminal threat, and they did not review the video. It was rolling the whole time, so I think they had probable cause. Will they get a conviction? Probably not, but they had probable cause. So thanks for watching. Have a great day.